The final collapse of a constitutional order is often announced by the official public denunciation of a state's own governing institutions. When the executive branch declares a segment of the judiciary to be a source of partisan activism, it is not seeking to correct a legal interpretation. It is seeking to delegitimize the very power that holds it in check. The White House's immediate, aggressive response to the judicial order releasing Kilmer Abrego Garcia, a response predicated on labeling the judge as a judicial activist, must be understood as a profound constitutional assault. The executive is not merely appealing a decision. It is asserting a political right to define the reality of the law itself, independent of the judiciary's fact-finding and legal reasoning. This is the ultimate stage of institutional erosion. A great power cannot sustain its global commitments when the foundational pillars of its domestic governance, the executive and the judiciary, are engaged in open, fundamental conflict. This internal war is the most reliable indicator of hegemonic decline. The official designation of a federal judge's ruling as judicial activism is not a term of legal art. It is a doctrine of defiance. It is a calculated political maneuver designed to strip the judiciary of its moral authority. In the eyes of the public and, critically, in the eyes of the executive's own enforcement agencies, the concept of separation of powers is predicated on mutual respect for institutional boundaries. When the executive attempts to enforce, it will by questioning the very legitimacy of the judicial process by suggesting the judge is operating on partisan bias rather than law. It is actively dismantling the framework of the state. This public, state-level rhetoric creates an environment where disobedience to the courts is justified, moving the nation from a system of rule of law to a system of rule by expediency. The administration's rationale for defiance is rooted in a specific set of allegations that Abrego Garcia is a proven human trafficker and a proven gang member. Yet, the judge's ruling, as noted in earlier analysis, was based on the simple legal fact that the government was holding the individual without authority and had engaged in demonstrable legal misconduct, including lying to the court. The executive's strategy is clear. Substitute fact with accusation. By repeating inflammatory, yet unproven, allegations, the administration attempts to shift the debate away from the state's own lawlessness, unlawful detention, misleading the tribunal, and onto the alleged character of the accused. This is a totalitarian technique. The definition of the enemy supersedes the requirements of the law. This manipulation of facts by the highest office in the land is a strategic vulnerability, as it confirms to the world that American governance is increasingly detached from objective reality. The legal core of this entire conflict is the principle of habeas corpus, the right to challenge one's detention. This is the Magna Carta of individual liberty and the oldest pillar of Western constitutional law. The executive's relentless fight against the release order and its earlier, documented effort to hold the individual without proper authority is a direct, systematic assault on this most fundamental safeguard. When a government fights harder to hold one individual unlawfully than it fights to address genuine, systemic security threats, it has sacrificed its strategic discipline for the sake of symbolic tyranny. The ultimate purpose is not to prosecute one man, but to establish the precedent that the executive can detain whom it wishes, for as long as it wishes, defying the judiciary in the process. This surrender of the habeas principle is the signal of a civilization willingly trading its liberty for the illusion of total security. The declaration that the administration will continue to fight this legal battle in court is a statement of political will, not a routine announcement of appeal. It signifies a policy of guaranteed escalation against the judiciary the executive, having lost on the merits and been found to have engaged in misconduct, chooses not to concede to the judicial mandate, but to double down. This approach ensures that the state remains perpetually consumed by internal conflict. This strategy is an act of strategic suicide, as it diverts immense legal resources, time, expertise, and political capital away from the nation's overwhelming geopolitical challenges and toward an internal, zero-sum war for institutional dominance. The administration's position rests on an implicit autocratic thesis that the executive branch alone possesses the competence and authority to define who constitutes a threat to the state, a human trafficker, a gang member, and, therefore, who may be held without regard for judicial process. In a functioning constitutional republic, the executive proposes and the judiciary disposes, acting as the neutral arbiter of law and fact. The current administration is attempting to collapse this distinction, asserting that its prosecutorial will must be absolute. This belief that the political judgment of the executive must supersede the legal judgment of the court is the philosophical foundation of authoritarianism. It is a profound, irreversible shift in the character of the American state, broadcast globally for all our rivals to observe and exploit. The method of the administration denouncing the judge as a biased activist, rejecting legal fact for political accusation, and then declaring its intent to fight on regardless of the ruling bears an unnerving resemblance to the tactics employed by the autocratic regimes we seek to contain. States like Russia and China routinely dismiss judicial or political opposition as the work of corrupt, partisan actors acting on behalf of foreign interests. When the United States adopts this language to attack its own independent judiciary, it forfeits its ethical distinction. It sacrifices the last vestige of moral authority that separates the Western democratic model from its autocratic rivals. This loss of distinction is not abstract. It is a catastrophic strategic defeat in the battle for global influence. The open, venomous conflict between the White House and the federal courts has immediate and severe geopolitical implications. Instability signal. It signals to allies that American domestic policy is subject to chaotic political will, making long-term strategic cooperation unreliable. Resource paralysis. It ensures that national security and defense resources are perpetually diverted to fight internal battles, starving crucial global initiatives of focus. Rival validation. It validates the narrative of states like China, which argue that the chaotic, contentious nature of democracy renders it unfit for the challenges of the 21st century. An internal institutional war guarantees an external retreat. The American state cannot effectively project power when it cannot even secure the basic constitutional consensus required for its own internal function. The administration's response to label judicial independence as activism is a demand for subservience from its own legal staff, DOI and DHS. This creates an internal crisis for the thousands of civil servants and attorneys who have sworn an oath to the Constitution. The choice is now simple and brutal: compliance with the political will versus adherence to the rule of law. This pressure forces capable professionals out of government, leading to an inevitable decline in the competence and ethical standards of the administration. When the state is staffed by political loyalists rather than objective experts, its capacity for strategic foresight and crisis management is severely curtailed, guaranteeing policy failures both at home and abroad. History provides clear warnings. Empires and republics do not survive when their governing institutions become tools for political revenge rather than instruments of public service. The decline of the Roman Republic was marked by the gradual erosion of its traditional legal and political checks, replacing them with the capricious power of ambitious men. The current attempt to dismantle the judiciary's independent role is an echo of this historical pattern. It shows a systemic failure to grasp the essential truth that institutional integrity is the highest form of national security. By prioritizing the temporary, symbolic victory of keeping one individual detained over the enduring necessity of upholding the rule of law, the executive branch is actively choosing the path of historical self-destruct. The confrontation between the executive and the judiciary over Abrego Garcia is no longer a legal case. It is the definitive referendum on American constitutionalism. The executive has openly rejected the judiciary's role, denounced its independence, and chosen to continue to fight for a political end against a clear legal finding. This choice represents the final, tragic surrender of the sovereignty of law to the tyranny of will. The American system, which was meant to be governed by abstract, enduring principles, is now openly revealed to be governed by the passing, vindictive desires of its political leadership. The world watches this descent into institutional anarchy, and it is drawing the inevitable conclusion. A nation that has lost control of its own constitutional boundaries is incapable of controlling the trajectory of the global order. The American century is concluding, drowned in the noise of its own internal, self-inflicted legal war.